Good morning. I'm Aaron Hall. In today's live Q&A, I will be answering your questions about business and the law. This is a mistake that forever changed how I managed people. In 2008, I was working as an attorney for a corporation. And the attorney that I reported to, who is the head of the department, was absolutely wonderful. Her name was Gina. She was fantastic, and she taught me a lesson that I will never forget. About a month into the job or so, I had a conversation with Gina, and she said, "Aaron, I appreciate how you want to do things right. And in doing so, you ask a lot of questions." Gina then said, "But Aaron, my brain only has the ability to make so many decisions per day. And so let's say, for example, you are asking me to make 30 decisions every day or asking me 30 questions every day. You're using up a portion of my mental capacity to make these decisions." So she said, "I need you to think through the decisions yourself and do the heavy lifting yourself. So I'm going to ask you, whenever you come in to meet with me and ask me, what should I do about this? Instead say, Gina, here's what I recommend we do. Here are the factors I considered. And here's why I recommend this course of action." And Gina explained to me, then, when you bring these matters to me, I can think through, is there any outside information that you don't have? And is there any weakness in your analysis? But that's much less intellectual work than having to do the entire analysis myself. So she said, from this moment forward, please only come to me if you have to. And she said, by the way, I trust your judgment. You can do a lot of these decisions on your own. After that, as I had questions for Gina, I would think through, what are the factors needed to identify the recommendation I would have for Gina. And many times after I thought through all of the factors and identified a recommendation, I realized I don't even need to go to Gina. The decision is very clear. And so I'd say about a third of the questions I simply no longer needed to bring to Gina, because I asked myself, what would I recommend to her? What are the factors I would weigh in making that recommendation? And perhaps what are the other options that are available? And after that analysis was done, I didn't need Gina's feedback. And when I did go to Gina, I would say, Gina, here's my question. Here's my recommendation for the answer. Here are the factors I considered. Here are the options I considered. And so in conclusion, I'd recommend this for these reasons. And she would either say, sounds great, do it. Or, Aaron, there's some additional information here that we need to consider, and I actually want you to do this instead. But I'd say about 80 to 90% of the time, I had all the information needed, and Gina just said, go forward with it. That was a valuable lesson to me, because later then, when I began managing a law firm, I started to realize a lot of people were coming to me and asking me questions or bringing problems to me. Somebody once said, think of every problem that an employee brings you as a monkey. And they say, hey, here's a problem. And we as managers, business owners, and CEOs, we may say, hey, we're pretty good at solving problems. We think we're pretty smart. We've gotten here so far. Let me solve that problem for you. It feels good for our ego. It feels good for our confidence. But when you solve an employee's problem and then essentially give that back to them, what happens is the employees learn that is the standard expectation. Bring the problems or bring the monkeys to the manager, and the manager will solve them and give them back. Here's the problem with that. Over time, as you have more and more employees and they bring more and more problems, those employees bring those monkeys to you, and eventually you have a room full of monkeys. And I found that. I remember at one point, I would have a line of employees waiting out the door to come in and run things by me for the first hour or hour and a half every day when I came in. That is when I started to implement the lesson that Gina had exemplified for me years earlier. And I've now started asking everybody who works with me, what do you recommend we do? And often I tell them this little story of Gina. So with all new employees, I tell them this story and I say, when you come to me with a question, would you please think through what are the options that for solving this problem? What are the factors we should weigh in coming to the right option or solution? And then ultimately, which one do you recommend? There's another really powerful benefit from this. Rather than making the decision myself, the person who's closest to the problem is doing the analysis. And often they have more knowledge about the problem because they're on the front lines. Often managers are too far removed from the problem. So it is the person more on the front lines who should be doing most of the analysis. Another benefit is you are empowering the people who work for you to become more capable, make better decisions, build their confidence, build their leadership skills, and ultimately help them be more effective in your business and in everything else they do in life. So rather than us taking the monkeys and taking the problems and trying to solve them, I encourage you to start asking your employees, what would you recommend? And what is the analysis that brought you to that recommendation? Now, it won't take away every problem, but it'll, like Gina found, it moves a lot of the decision making to the person best equipped to make it. And that way, you as a manager are only scrutinizing the analysis to see if there's any additional information or analysis that needs to be brought to bear on the decision. So that is a valuable lesson that forever altered how I manage a team. And I simply remind myself this little phrase, what do you recommend? And I actually will tell the people that I work with, if I ask you, what do you recommend? This is a reference to this whole concept. And if you're not quite sure, that's okay. Go ahead and go back, analyze the situation, think about the options, select your recommended option, and go from there. I have also found that as an attorney, my clients love it when I do that. Instead of saying, hey, client, here's a problem, I say, hey, client, here's a problem. Here are the options. These are the factors to weigh in selecting the best option based on your concerns and goals. Here's my recommendation. What do you think? And then the client can decide for themselves, is that the way they want to go? Or is there some additional information that needs to be factored into that decision? All right. We have a question from Jeff. Let's see here. Okay, it says here Q formation. Oh, question. Formation of an online magazine. How would you structure it and address the most pressing legal concerns? All right, so let's see here. What is the question here? How do you avoid the most common legal problems when setting up an online magazine? So this is a new company. Maybe it's a blog. Maybe it's a blog that makes money through affiliate links or selling some services. Maybe it's an online magazine, which is much like a blog, but often makes more money through advertising. Perhaps there's a portion of the magazine that's behind a paywall, and the paywall is a spot where if users pay, they have access to more information. So here's what I would be thinking about. First, in which state is the owner located? Because usually you are going to be taxed at the income tax level in that state. If you don't have a state with income tax, great. That may be a good state to be located in. I would also ask the owner, are you concerned about privacy, or is your name going to be associated with the business? There are certain states, Minnesota, Wyoming, etc., where the owner can be kept confidential from the public. Now, the government is always going to know who the owner is because tax authorities need to know that. So if it's important to keep the owner's name confidential, we would probably look at setting the business up in a state where confidentiality of the owner is preserved. That might be Minnesota, for example, if the owner's here. But Minnesota has a state income tax. And so we might take that into consideration and look at a different state if the owner is let's say the owner lives in Texas, where there is no state income tax, I believe. A Texas owner would probably not want to set up a Minnesota LLC. We'd probably look at a Nevada LLC. So privacy of the owner and income tax considerations are important. All right, then once we've identified which state to set the business up in, we would look at LLC or S corporation. Why not C corporation? Because C corporations are taxed twice. And so for most business owners, that's not the way you'd want to go. There are some exceptions, like if you don't plan to have profits for a number of years, or if you are doing special tax planning where you want the C corporation to be able to deduct certain expenses that an S corporation couldn't. But by and large, an S corporation or LLC are the best options. So from there, do you want an LLC or an S corp is the question. If you're going to be working in the business, and if the business is going to have significant profits, then generally speaking, you want it to be an S corp. And in fact, even if you're not working in the business, you probably want it to be an S corp. I have a separate video on trying to decide between LLC and S corp, so I'm not going to go too deep into that. We'll add the link later when this video is published. The next question is, what contracts do you need with important relationships? Well, you're going to have contracts with readers. That's the privacy policy and the terms of use or the terms of service. So you'll want to make sure that is taken into consideration. Next, if you have any paid subscribers, you have a contract with them. That's behind a paywall, typically. So make sure you have a solid contract there. Third, if you have any advertisers, you'll have a contract with them. Now, if you're using like Google Ads, you don't have to worry about a special contract there because Google has a contract. But if you have advertisers who are paying for space on your website, you'd have a contract with them. If you have affiliate links, it's important that you have a disclaimer related to those. And then once you have contracts for all of your important relationships with the outside, you'll want to think about any contracts you have with important relationships on the inside. So that's independent contractors. You'll probably want an independent contractor agreement, or at least consider whether to have one. Why is that important, by the way? Two really big reasons. One, you designate who owns the intellectual property contractors are creating. The default is contractors own it. So if you're paying them to create something for you, you want a contract that gives you the intellectual property rights. The second reason is you need to have confidentiality provisions in there. If you don't, you're essentially waiving trade secret rights as it relates to any confidential information the contractor has access to. So for example, with an IT company who has access to all data in your computer, you are running the risk of waiving all of your trade secret rights if you don't have a confidentiality provision in your contract with the IT provider. Next, think about the relationship you have with employees. Now, usually you don't have a contract with them. You have an employee handbook, and that employee handbook sets forth all your policies and employees' rights and procedures as it relates to the employee relationship. Now, you might say, why not have a contract with employees? Why is it an employee handbook or policy? You can change employee handbooks and policies at any time in the future. You don't need employee permission to do that. But contracts require employees to agree to the new terms. So usually you only use contracts for something that won't be changing, and you are locking in rights of an employee and an employer. Whereas an employee handbook, which is a collection of employee and HR policies, you can change that handbook at any time. All you need to do is notify the employees that you have changed the policies and they're now subject to it. A best practice is to also have the employees acknowledge that they received the handbook and have read the updated handbook, but that isn't always necessary. So now we've talked about the big relationships with the outside, relationships with the inside. What else should a magazine or a publication business be attending to? You may want to trademark your brand name. You may want to copyright what you create, the artistic works that you create, whether it's videos or text or images. And you might want to register those intellectual property protections. If you have any slogan or logo, you might consider trademarking that. You will need to set up an entity. We talked about that in the beginning, and you might need to register in a city, county, or state. So you'll want to work with an attorney familiar with those in your local jurisdiction. A magazine doesn't have any requirements to get licensed, but you probably have a requirement to register with your state, especially the state tax authority, because you may have an obligation to start collecting sales tax. You may have an obligation to start collecting payroll tax. And then typically you have tax returns associated with those. And you want to know in advance, are those due monthly, quarterly, or yearly? It depends on your state. And then even within states like Minnesota, your obligations may depend on how much you're actually collecting. Those are some of the big legal concerns or steps to avoid problems in the future. You might also consider getting insurance to mitigate any risks that you have out there. For example, the risk with a magazine is potential defamation. So you'd want insurance against that. Perhaps intrusion upon seclusion. I'll cover that probably a little bit later today or in another show. But you want some protection for the tort of inclusion upon seclusion. And that's where you publish private information and you have legal liability for it. You might also want liability for some sort of errors in what gets published, or you might want insurance for that liability. All right, let's take a look at the next part of the question here. Let's see. Okay, it looks like we might have addressed that. So essentially, just to recap, that was how do you or what factors do you consider when setting up a legal structure and avoiding legal problems for a startup online magazine? Let's move to the next question now from Brendan, the owner of Welch Racing Company, LLC. How do you get out of business interruption that is stemmed from malicious defamation, malicious falsehoods, and severe stalking, harassment, and cyber stalking? And what's the best way to find partners or investors for a bailout or help in a financial situation? Okay. All right, so I'm going to phrase the question this way. When your business is facing a variety of legal threats and problems, what are your options? I'm going to approach this in a holistic way because this is not a unique situation. In fact, many small businesses fail. And if you are a business owner who's going through legal trouble, you are feeling a variety of complex emotions and dealing with complex problems. Here's some of what you're dealing with. You feel overwhelmed because you don't know, you don't fully understand and are new to all the legal terms and concepts, claims and threats related to what you are encountering. A lot of times you feel like these are false accusations. There might be some truth to it. You might have had some liability, but you don't quite know where those lines are. What did I do wrong and what was justified? So that's the legal overwhelming piece. You probably are also dealing with difficult financial circumstances because usually the legal stuff causes financial problems. Perhaps you haven't been paid what you're supposed to get paid by people. Perhaps you're spending a lot of money on legal fees. Perhaps your attention has been focused on the lawsuits and the legal problems rather than growing the business and keeping it going and making money. But it is very common when companies go through legal problems to also be facing financial crises. You may also be dealing with difficult relationship circumstances, whether that be a business partner, employees who are feeling the heat from what you're doing, a spouse or a relationship partner who is trying to provide support during this time or is feeling stressed by what you're going through, because you need somebody to talk to about some of this stuff. You want to be transparent to some extent with a partner about what's happening to the extent that the crisis affects the partner. And so when a business is going through all sorts of issues, it's rarely isolated to some little problem. It's affecting big relationships in the business, big relationships outside the business, the finances, and then, of course, your mindset, emotionally, psychologically. The toxicity associated with these sorts of problems significantly affects a business owner's optimism and energy to grow a company and hope in making the company better and the hope needed to pass on to employees the positive energy of working in a business. So sometimes you even find employees start leaving because of the problems, or you start firing employees because there are so many problems and employees, there are misunderstandings that occur. What is a business owner to do when faced with these problems? Well, and this is not easy to do, but step number one is to try to get a little space from them and think through, who are the experts I need to get into my corner so that I can start solving these problems strategically and methodically and objectively. When I have had legal trouble, I hire attorneys, even though I'm an attorney. Why? Because you're too close to the problem when you are enveloped in it. You need somebody who's both an expert and objective to take a look at it. So my best advice for business owners who are going through chaos or all sorts of legal problems is sit down with an attorney who understands the complexities of this area of law and can help you put together a customized plan of attack, prioritizing items based on urgency and importance, and methodically going through and working out a solution. If you're looking for an attorney in this area, there's a term for it, and it's called a turnaround attorney. In other words, when a business is going through chaos, there are turnaround experts who will come into a business and are familiar with how to solve chaos and get clarity and put together a plan for the business to turn around and get out of the problems it's facing. So consider looking for a turnaround expert or a turnaround attorney. I do this regularly with businesses, and then that turnaround expert can identify what legal options would be best available to help. Maybe it's bankruptcy, maybe it's settlement negotiations, maybe it's litigation. So I could at this point try to get into analyzing some of the subject matter that was brought up in this question, but I think I would probably be doing the person who asked the question a disservice, because in order to put together a solution, the expert really needs to spend time to understand the circumstances and the law in the states where the problems exist, and then put together a plan of action. For example, some states have laws that protect you for certain sorts of defamation, where other states don't provide the same level of protection. And there are other aspects here where stalking, for example, might be criminal in one state and it might not have significant consequences in another state. There might be free speech rights that come into play here. So there's a lot of different legal pieces to weigh. But I think when a business owner is facing a significant legal crisis that threatens the business, whether that be a crisis from with partners within or people on the outside, the best bet is to go consult with an attorney and talk through the details there. I wish I could give you more advice, like here's exactly what to do, but I think I would be doing you a disservice by being overly generic and overly broad, when what you need when you're going through a crisis is somebody who will take the time to understand the circumstances and put together a specific plan to turn around the business and get you out of it. And make sure that you understand all of the risks that are associated with the different aspects of the legal problems, and decide which risks you're willing to accept and which you're not. And then, of course, the cost associated with the different solutions you identify. Brendan, if you have specific questions about specific areas of law, you are welcome to add those in the comments section, and I'll do my best to answer them. But keep in mind, I'm going to answer them from a generic educational standpoint. And if you are going through significant legal problems, you are best served by using what you learn today to talk with an attorney in your state who can actually help you with the specific issues. Next question. Why did Taylor Swift have to re-record her albums? Didn't she own them? This issue comes up not only with musical artists, but it also comes up with artists who do paintings and other creative works, graphic artists, video artists who create videos. And what happens is you often, in the beginning of your professional artistry, sign a contract. And you sign a contract with either an agent or a management company. And basically what happens is the company says, instead of you having to pay all of the money to grow your business, we as a management company will pay those costs. But in exchange, you are giving up future rights to profit. And so apparently that is exactly what Taylor Swift did. Although she wrote her music and she owned the copyright in the written form of her music, when she went to record that, the recording is now a new form of the music. And so the recording, whether it has drums or guitar or piano or whatever was in that recording, that is a different form. And so it has a new copyright, a copyright that is totally separate and distinct from when she wrote the music. And apparently Taylor Swift had given away the rights to the recorded versions of her music. And then it sounds like those rights were then sold to somebody that Taylor Swift was no fan of, and there was some ill will there. So now that he owned the rights to her recordings, she was concerned that, hey, first off, whenever she uses these recordings, he's making money. And in fact, she may not make much. She might still get a percentage, but she decided, hey, what are my rights here? And she probably spoke with an attorney. That is, Taylor Swift probably met with a copyright attorney who said, hey, Taylor, you don't own the recordings, but if you re-record the songs you wrote, you would own the new recordings, and there's nothing in the prior contracts that would prohibit you from doing that. Now, by the way, they could have put something in those contracts that said, we own the rights to this song's recordings, both recordings that exist now or any in the future. But it appears that that was not in the contract that Taylor Swift had with the management company. So by Taylor Swift re-recording her music, she was able to own that recording entirely and remove any obligation to pay money to the owner of the old recordings. Now, those older recordings can still sit out there. They might sit on Spotify or whatever, but the owner of those old recordings gets no money from the new recordings that now get played on Spotify. And that, by the way, is why Taylor then went out and started encouraging her fans, listen to the Taylor version. Don't listen to the old version, because if people are buying the new version and listening to the new version on Spotify, then with Taylor's version, the money goes to her, not the person she didn't like, who owned the rights to her old recordings. All right, let's take a look at the next question here. All right. Can someone really force you into bankruptcy? Let's talk about what's called involuntary bankruptcy. Although rarely used, did you realize that someone you owe money to can force you into bankruptcy? It's called involuntary bankruptcy. Basically, if you don't pay your debts to a creditor, they have the option of forcing you into bankruptcy. The main requirement here is that you are not paying your debts. Now, there are some other requirements and there's some exclusions. For example, you can't force a bank into bankruptcy. You can't force a nonprofit into bankruptcy. There's some other exceptions that are there. But this is certainly a risk. If you have substantial debts and you're not paying those debts, and especially if you're not making a good faith effort to pay those debts, if a creditor wants, the creditor can spend money to force you into bankruptcy. Creditor is just a simple term for the person you owe money to. So how that works is the creditor files in the bankruptcy court and asks the bankruptcy court to initiate an involuntary bankruptcy against you or your business. Conversely, let's imagine somebody owes you or your business money. You have the option of asking the bankruptcy court to commence an involuntary bankruptcy against that against the person who owes you money, the debtor. Now, there are some reasons you may not want to do this. First off, it's expensive. There are legal fees involved. Second, it takes time. Third, the bankruptcy court will take a look at all the other creditors that person owes money to. And usually it's divided up with a percentage to each creditor. Now, how the bankruptcy court does that depends on the circumstances. But the bottom line is you might not get it much if you force that company or that person who owes you money into bankruptcy. You may be better off getting a settlement where they pay you a certain amount of money as a lump sum, or you can work out some other arrangement. But if they're just ignoring you, you can either sue them or you can look at an involuntary bankruptcy, which essentially still requires you to prove in the bankruptcy court that they owe you money. So typically you're going to work with a sophisticated bankruptcy attorney in order to do this. This is not your classic bankruptcy attorney who helps people file for bankruptcy. Typically it's an attorney who represents creditors in bankruptcies. These attorneys aren't cheap. They typically have higher rates than most attorneys. They're often in larger law firms. So if you are looking to force a person to pay you money, I recommend either working with an attorney who represents creditors in collections or looking for a creditor's bankruptcy attorney. And most of the small bankruptcy firms, they represent lawyers who help people file bankruptcy. What you're looking for is a law firm that will represent the creditor against an individual who owes the money. All right, let me take a look. I have a follow-up question from Brendan. So I don't know the details of this situation, but I'm going to phrase the question this way. If you are the victim of defamation, falsehoods, libel, and intellectual property theft, what should you do? Well, the classic answer is either you try to resolve it yourself or you get an attorney to help you to try to resolve it. And typically, if you're asking this question, you've already tried to resolve it yourself. Or it's too big of a problem. So let's assume you need an attorney. The attorney will usually decide with you, does it make sense to do a demand letter where you demand some sort of payment or action to resolve this? Perhaps you send a cease and desist letter, which says, hey, cease and desist your illegal activity. By the way, you could combine those into a single letter. So you demand money and ask them to cease and desist illegal activity. Or you might decide, let's go straight to court. These guys are not cooperative. They're not reasonable. We're going straight to court. We're going to sue them. Or you might decide it's not worth suing these folks. Maybe they're in another country where U.S. court systems are not honored. Let's say, for example, the party doing this is in Russia. Good luck trying to sue them in the United States. Yeah, you'll probably get a judgment, but then what are you going to do? Let's say you win and you get a default judgment against them. But what all that a judgment is a piece of paper that now says they owe the money. If they don't have anything in the United States, you have to go to Russia to enforce that judgment. Now, maybe they do have something in the United States. Maybe they have a bank account. Maybe they have a website or a domain name. If they have any assets in the United States or within the jurisdiction of the United States, maybe it is worth getting a Minnesota or a United States court judgment against them. So if you are the victim of defamation, falsehoods, libel, intellectual property theft, etc., the next step is usually talking to an attorney who can analyze not only the legal ramifications and your legal options, but your practical ones as well. How much money do you really want to spend to deal with this? And what is the chance you're actually going to collect or prevail against the other party based on how much money do they have? Are they located in a jurisdiction where a judgment would be enforceable? Do they have any property assets like domain names or bank accounts or funds that you could go after if you win in court? All of those would be factors to consider in determining what strategy makes sense for the next steps for you. All right, next question from Brendan. How long does it take after filing to get a court date for a hearing to get injunctions in place? So the short question here is, how long does it take to get a court injunction? In extreme situations, you can get a temporary injunction the same day. In most circumstances, you are looking at about 2 months. And there are options within that. So let's give an example. Let's say that, and this is an extreme example. Let's say every day, one of your customers comes to your business and beats you up, threatens to kill you, and takes some of your computer equipment. Now, again, I'm picking a ridiculous extreme scenario. Or let's assume some sort of damage online. That would probably be justification to go to the court the same day. And courts, at least in Minnesota, and I believe most states, have a judge who is appointed to just deal with stuff that comes in. And usually, by the way, it's for domestic abuse. But you can use these judges for some sort of business extreme circumstances as well. And what you would ask the judge for is a temporary restraining order or a temporary injunction. Now, usually, because nobody is there to represent the other side, The judge is very cautious in giving an order like this. The judge will want to be convinced that your arguments are true. You will be required to put under oath what has happened to you. And the judge will need to determine that it's extreme enough that the judge should issue an order even without hearing the other side's position on the issue. That typically can allow for a temporary restraining order or a temporary injunction. But usually that's for a minimal amount of time until the other parties can get in and both sides can be heard by the judge. In extreme situations, I've had success having a same-day hearing and then another hearing a week later. And usually the judge will say, I'm issuing a temporary injunction for 1 week, but I want all the parties notified and in here. And if all the parties aren't here in a week, this injunction ends and I'm not granting another one. So the judge has basically said, we have 1 week to notify the other side of the hearing and file all the documents and evidence and legal arguments in writing to request that the injunction be extended. So we might get a 1 week temporary injunction or temporary restraining order, but to have that extended beyond 1 week, like for a month or for a year, requires typically a hearing of all sides and the full paperwork required in a normal motion brought before a judge. So if you are in a domestic violence situation, you probably don't need an attorney. You can just go down and get a temporary restraining order. But if you're a business or other circumstances, I'd recommend working with an attorney who is very familiar with this area of law and how the court system works so that you can get the most protection you need and stop the illegal behavior that's hurting you or your company. All right, next question here from Brendan. I've read that you don't sue unless you can collect. It's not just injunctions, but also about money. I know the people who have assets like race cars, dragsters, and trucks, etc., that I can get seized. Is there also a wage garnishment? So I think I'll rephrase the question in this way. How do you collect once you win a lawsuit? So a lawsuit can give you two things. It can give you an injunction, which is where the court orders a person to start doing something or stop doing something. But the court can also order the payment of money. And so let's say, for example, you win a judgment against another party for $1 million. Just hypothetically, I'm picking a number that's large enough that it's worth going after. You know, if it's $5,000, you don't want to spend $15,000 in legal fees going after it. But if it's $1 million, you'll spend some money and put some attention into collecting. And let's say hypothetically you get a judgment against a business and two of its owners. And let's say those owners have some fancy vehicles or some expensive vehicles or some real estate, maybe some other businesses. How do you collect the $1 million that you are owed from the business and the two owners? Well, first off, once you get that judgment from the court, and let's assume it's docketed, which means and it's filed and typically there's an appeal period that needs to run. So maybe 60 days for appeal. What you will typically do is sit down with a creditor's attorney. This is an attorney who helps creditors who are owed money, and it helps you collect. And those attorneys are going to work with you either on an hourly basis or a contingency basis. Contingency means the attorney doesn't get paid unless they collect money for you, but they're going to get a percentage of whatever they collect. And let me tell you something about attorneys who do collection work on a contingency basis. They don't take work unless they're pretty confident they're going to get paid. and they want to make good money, not just a little bit of money. So if they think it's going to take a lot of effort to get paid, or you're unlikely to get paid, or you're going to get paid a small amount, collection attorneys won't take the case on contingency. But if let's say, for example, the attorney figures, you know what, you're likely to get paid here, and you are likely to get $1 million. The attorney might say, hey, I'll work on a 40% contingency, which means if the attorney collects $1 million, the attorney gets $400,000. And the attorney might think to himself or herself, I'm going to put into this $50,000 worth of work, but I'm likely to get $400,000 in contingency fees. That's a good deal. So that's the analysis that collection attorneys go through when determining whether they'll offer to work on a contingency basis or not. So likewise, you should be thinking about, do I want to really give up a contingency percentage, or do I want to pay by the hour? I have a great article on contingency attorneys and this whole analysis. We'll add a link to that later so that you can be thinking about whether a contingency attorney is best for your circumstances. They're sometimes called a no-win, no-fee attorney. All right, so you've decided to hire a collections attorney, though. You figured out some way to pay them. What's the next step? Typically, a collections attorney is going to run a report, which is either provided by a private investigation firm or a public database that identifies all of the public records related to ownership of the defendants. And in this scenario, we're talking about a company and two individuals. So it might say, hey, this individual owns this vehicle, this vehicle, this vehicle, this home, this real estate, this business, this motorcycle, whatever it might be. And then what the collections attorney may do is start immediately going after those assets by either garnish. By the way, you often find out about bank accounts as well. Garnish the bank account, levy the bank account. What's the difference, by the way? Garnishment is when you freeze assets. Levy is when you take them. So you have to freeze the assets before you can take them. So typically, a collections attorney will garnish an asset so it can't leave, and then take it. So we're talking about like bank accounts here, where a bank account has funds in control of the bank. The bank will garnish those funds, which means freeze them so the owner cannot withdraw them. And then once the statutory process is complete, the bank will release those funds to the creditor who's owed the money, and that's called a levy. Or the bank will levy them and take them and then release them. But all right, so long story short, there are statutes in every state that provide how a creditor can start with a judgment, can start taking assets of somebody else, whether it's through a sheriff's sale, garnishment, levy, etc. These laws vary by state. And so if you need to collect on a large judgment, you will need to work with an attorney experienced in collections for creditors. If you go to an attorney with $1 million debt, but you haven't yet obtained a judgment, the attorney will usually tell you they need a higher percentage, or it's going to cost more, because they have to go out and sue the case out to get that judgment first. If you've already gotten the judgment, it'll obviously be less work for the attorney, so the attorney's rate on average will be substantially less. So to conclude, if you have a judgment against somebody because you've won against them in court, can you go after a bunch of the stuff they own? Their cars, their properties, etc.? Yes, you absolutely can. You can start taking all of those assets. And often they'll offer you money in exchange for keeping those assets if they really want to keep them. There are certain certain assets that you cannot take. Every state has what's called an exemption statute. For example, it typically says a personal residence has a certain amount of exempt equity. So you can't take a person's home unless it's a large or expensive home that's worth more than the exempt portion. Minnesota's exemption statute has a number of other unique things. You can't take their family Bible. You can't take an instrument. You can't take a family heirloom up to a certain value. There are certain things of kind of sentimental value that you can't take. So you'll want to look at your state's exemption statute to see which assets are exempt from creditors. Later in this video, we'll put a link to an article I've written on which assets are exempt from creditors in Minnesota under Minnesota's exemption statute. That will at least give you an example of the options here. All right, let's see where we're at here. All right. We will keep going with the next question. Should a company that won a large lawsuit set up an LLC, S Corp, or C Corp? Here's the specific question. It was posted in a comment on YouTube. We have a third-generation C Corp that won a 25-year lawsuit. So I'm going to assume that's a lot of money. That judgment is considered income. Great observation, by the way. Whenever you get a judgment, typically that is income and thus subject to income tax. Now, the only time it wouldn't be is if it is compensation for a harm, and that then gets into certain tax rules and how that was reported to the IRS in prior years. But I'm just going to take as true the assumption that in this scenario, the judgment is going to be large and subject to income tax. I'll proceed with the question. We no longer want to continue with the business and what we've done in the past. The company has a lot of income coming in from the judgment. What would you advise us? Would you advise us to let the C Corp be a holding company and make any new investment in an LLC under it, or switch to an S Corp? So the first question in the analysis is, should you have a new company or keep using your existing company? The second question is, should that new company be a C Corp or not? And the third company is, should the new company be an S Corp or LLC? So first, should you set up a new company? You may not be able to. And here's why. If the money is coming in to an existing company, that company is the one that will have to receive the check. And if that company has creditors out there that it owes money to, then some of that money will have to be paid out there. You can't just move all of the money to a separate LLC and have it be protected from creditors of the original company. You also cannot just have the lawsuit money paid to a separate company. It needs to be generally paid to the company that won the lawsuit. But let's say you don't have any creditors. Then what do you do with that money? At that point, I would work with a CPA to think through, are there any tax consequences to what you're weighing here, and make sure whatever you do is with knowledge of any tax consequences. But usually what happens is the money from the company is distributed to the shareholders, and then the shareholders can do whatever they want with that money, like investing it on their own. But let's say for some reason you don't want to distribute the money from the corporation to its shareholders. Then what do you do? Well, if the corporation is concerned that it might have some liability later that could put that money at risk, like let's say, for example, a customer could come from 3 years later and sue the company. So the corporation may not want to have that money sitting there exposed to creditors who would come down the road. What you may want to do then is transfer the money to a separate business. There are going to be what's called look-back periods. That means if you transfer the money and a creditor sues the original company, the creditor might be able to have the court pull that money back, which is called disgorgement. Disgorgement is when the judge orders money to be disgorged from the old company and transferred back to the original company so that it is available to be paid to the creditors. And that period of time in which disgorgement can occur is called a look-back period. It's the period of time in which a judge can look back and say, hey, do I want to undo a transaction? But you might as well get the money into the new company and work with an attorney on this so that it's done right, so that hopefully the look-back period passes before some new creditor comes along and makes a claim, and then you now have that large amount of money exposed. Now the question then is, should that entity be an LLC, S Corp, or C Corp? Usually you don't pick C Corp because it gets double taxation. You're probably going to have it be an S Corp or an LLC. If the LLC is owned by individuals, or if the entity is owned by individuals, then you would probably have it be an S Corp, but that should be a decision made by the CPA. And that's so that you can reduce payroll tax or self-employment tax. If the entity is going to be owned by another business, it may need to be an LLC, because as a general rule, S corporations need to be owned by individuals, not businesses. So in that case, let's say you had that LLC holding all of the assets, and it is owned by a company. The LLC then would pay the profits to the company, and then ultimately it would come to you, and it's very possible it would be subject to 15% self-employment tax. Bottom line though, this gets complex when you're dealing with multiple entities. It also matters how those entities are taxed, and a CPA is best equipped to help you figure out the structure that will minimize taxes for you in a way that's defensible with the IRS. And there might be some judgment calls here. And if a CPA has a judgment call, the CPA might say, hey, you can do this option, but it's more risky and saves more money on taxes. Or you can do this option. By working with a CPA and relying on the advice of a CPA, usually you have some protection under the law, because one of the defenses for tax fraud is you relied on the advice of a licensed professional. So I don't recommend doing this stuff yourself, and certainly don't make these big decisions based on what you hear me talking about here. The reason I'm explaining all this today is so you can get a framework for how these decisions are made and identify what topics to bring up with the professionals that you work with. So I would work with a licensed CPA who deals with small business owners and ask that CPA to put together a plan for you. By the way, it's not going to cost that much to get some recommendations from a CPA. I would think for less than $1,000 in CPA hourly time, you would have 1 or 2 meetings with a CPA, and the CPA could come up with a very specific plan for how to do this. The cost to implement it might be a couple $1,000s more, but that is minimal compared to the risk of doing things wrong and either having a huge tax bill or liability for tax fraud or not paying the proper tax amount. All right, next question. This question is from Max Hugan online on YouTube. Does a lawsuit winner always get legal fees reimbursed? The answer is no. And you might be surprised by this because you often hear about in the news parties are seeking reimbursement of legal fees. Now, first off, most lawsuits ask for reimbursement of legal fees even if they don't have a chance of recovering them. But you might be asking, well, when can you recover attorney's fees and when can't you? You might have heard about the loser pays rule. The loser pays rule says whoever loses the lawsuit pays the attorney's fees for the other side. In the United States, we call that the English rule. The idea is that in England, the rule may be that the loser pays the lawsuit. But in the United States of America, the courts have determined, and I should say the legislature and Congress have determined, that we don't want to incentivize people to litigate and force them to have to resolve this through the court system to get their legal fees reimbursed. We want to discourage litigation. Let's face it, United States is litigious enough. So, in the United States, the general rule is you do not get your attorney's fees when you win, unless there is a statute or contract that allows for it. And when I say statute, I'm including administrative rules. But basically, if there's not a law that allows you to recover the attorney's fees you spent, and there's not a contract that allows you to recover it, then the general rule is you can't recover it. Now, there are some exceptions. In court rules, for example, if somebody does something bad or violates serious rules, there may be, the court can order one party to reimburse the other for legal fees in that particular hearing or that particular event. But it is not for the whole case. It would just be for those particular issues or events. So it may be shocking to hear this, but you generally will not get your attorney's fees reimbursed if you win, even if you win huge in a lawsuit. The only exceptions are if a statute or some other law or a contract entitles you to recover attorney's fees. So when drafting contracts, I encourage every business owner to think about whether you want the right to recover attorney's fees. I observed one time when a company did great work for its client, and the client said, "We would like a 30% discount or we're not going to pay." And the company said, "Well, why? Why? Was there something wrong?" "No, there's nothing wrong." But essentially what they said was, "We know that you're going to have to sue us, and it's going to cost you a lot more money than you'll be suing us for. So if you don't give us a discount, we're not going to pay you." When that company brought this scenario to me, the first question I asked was, do you have a contract with them that allows you to recover attorney's fees if they don't pay? Unfortunately, the answer was no, which means the American rule applies and they have no right to recover attorney's fees. In this case, attorney's fees would cost more suing them than the amount in dispute. And so as a result, they had to take a lesser payment for their services because they had no other option. That's how some unscrupulous and dirty companies play the legal system. And if you want to protect yourself against those sorts of predators, you as a business owner will think about, should I put in my contract an obligation that if the client doesn't pay their bill, I have a right to recover attorney's fees? One other issue comes up here, and that is, if we're in a settlement, can we recover attorney's fees? Well, whatever parties will agree to when settling the case is enforceable by law. So if a party agrees to cover the other party's attorney's fees, then that's their right. And basically, now you have a settlement agreement, which is a contract allowing for the reimbursement of attorney's fees. But usually, a demand for attorney's fees in settlement negotiations is the first thing to go, because every attorney knows a settlement involves a significant compromise between the parties, and neither side is going to get their attorney's fees covered in most situations. In fact, I don't think I've ever seen a case that I've worked on where there was a settlement and one side paid the other side's attorney's fees. They always ask for it, but in settlements, it's a compromise, and attorney's fees are the first part of the settlement offer to be rejected by the other side. Part of it is because, hey, both sides have attorney's fees. Why should I pay yours? You should pay mine. And that kind of argument goes nowhere. Okay, next question. Can an attorney withdraw from a case for mental or health reasons without proof? This was asked by Skater Lover, 1999. Okay, let's kind of, there are two ways to look at this. So an attorney wants to withdraw. If this is not a legal matter presently in court, then you don't need to get any court's permission. And usually an attorney can withdraw as long as they give enough time for the client to find another attorney to take over the case. For example, you can't do it right before a deadline as an attorney. But attorneys have a right to withdraw for mental or health reasons usually, as long as they do it in the right way and with enough time. You might say, well, what is the right way? And what is enough time? For that, we would look to the laws that govern the attorney's license. They're usually called the ethics rules. Every state has ethics rules that govern attorneys. And so you would look at the withdrawal from representation of a client section of the ethics rules. But usually what they say is an attorney can withdraw as long as it's not prohibited by law and as long as the attorney gives proper notice. And frankly, sometimes attorneys just aren't getting along with clients, or the clients won't take the attorney's advice. So the attorney can withdraw for that or other personal reasons. Now, if the case is in court, then the question is, do court rules require the judge to give permission for the attorney to withdraw from the case? As a general rule, courts require the attorney to get permission from a court. This is true in most criminal cases. This is true in most federal courts. This is true in many civil courts in various states. In Minnesota, if there's not an upcoming deadline and it's a civil case, usually the attorney can simply withdraw without the court's permission. That assumes the attorney is doing it for the proper reasons as provided in state ethics rules. Let's see the next part of this question here. Oh. Is it okay for an attorney to withdraw from one client for mental or health reasons, but not all clients? Assuming that state rules and court rules do not prohibit an attorney from withdrawing from a specific case or a specific client, usually the attorney can withdraw from a client's representation for any reason or no reason. It could simply be, I don't have enough time, or the client and I have conflict, or I don't believe I can do the best work for this client that the client deserves, or other legitimate reasons of that type. What are illegitimate reasons? Well, you can't say, oh, I don't like the client's skin color, or I don't like the client's religion. That's discrimination. You generally can't do that. There's certain protected classes for discrimination. But for non-discriminatory reasons, generally an attorney can withdraw for other reasons. And that means withdrawing from one client where there might be a lot of conflict or turmoil or stress, and not from other clients. You know what, I'm going to go back. There's a question of whether an attorney has to provide proof of health or mental health reasons when withdrawing. Usually there's no proof required unless a court or a specific ethics rule requires it. That proof might be simply a statement under oath from the attorney. So it may not be outside documentation, but it is possible that the attorney would need to provide additional detail, like I recently consulted with this licensed medical professional who has given an opinion that I should withdraw from this case. Or the attorney might provide medical records of some sort. Or the attorney might provide a statement from the medical professional that says they need to withdraw. Judges have a lot of flexibility in what they can require of attorneys based on the specific rules for state or federal court. So the short answer is, generally an attorney can withdraw without proof of mental or health reasons, but all of this is subject to each state's attorney ethics rules and any courts where that attorney is currently appearing or on file. The attorney will need to follow the court rules and any requirements issued by the judge in that case. Okay, next question. This again is from Skater Lover 1999. Can an attorney withdraw if a case gets too complex for them? Yes. In fact, most attorneys have a duty to withdraw if the case is too complex for them. Why? Because in most states, there is an ethical rule, which is essentially a law for licensed attorneys, that says you must be competent in everything you do. That means competency means you must act as a reasonable attorney would, a reasonably prudent attorney with knowledge of the subject matter and experience in that particular area. And if the attorney cannot perform in a competent manner, not only can they withdraw, but legally they must withdraw or they must get some other help. So let's say you as a client don't want them to withdraw though. Let's say that you hired this attorney and now it's getting complex and you want them stuck on the case. You want them to finish it out and the attorneys want to get off. Well, first off, just as a practical matter, forcing someone to do work for you is usually futile because you're not going to get the best quality work. You're going to get the bare minimum. But setting that aside, there may be a scenario where you have a lawful right to keep that attorney on the case and require them to get help from another expert attorney to augment the attorney's weaknesses or incompetency. For example, let's say it's the day before trial and you have a 3-day trial. The other side has offered a settlement amount that you don't want to agree to. And the attorney comes to you and says, hey, I don't feel ready for trial. I don't feel competent doing this. I'm going to withdraw. Most likely that is a violation of ethics rules because there isn't enough time for you to go find another attorney to get ready for the trial, which is the next day. So most likely, if the attorney did it, the attorney would be subject to a very serious ethical violation, and the ethics board or department in your state could issue various penalties or consequences, including fines, suspension of a license, or revocation of a license. But you still might be without an attorney because even if the lawyer violates the law, you still might be out. Now, if you lose that case because the lawyer didn't represent you, you may have a claim to sue the lawyer for malpractice, basically arguing that if you had had that attorney there, the attorney would have won and you wouldn't have lost. But those cases are always tough because you have to prove the attorney would have won. And the reason the attorney withdrew is because the attorney felt he or she was incompetent. So, messy situation. What should you do? I would reach out to the ethics board in your state to get some guidance, and they might provide a little help. But otherwise, you will probably want to hire an attorney who can take a look at this, and the ethics board might be able to send you to a list of attorneys who deal with malpractice or ethical violations of this type. All right, let's take a short break, and we will then be right back with a few more questions. All right. When should a small lawn mowing, when should a small lawn mowing business get an LLC? Let's face it, there are a lot of small companies out there that don't want to spend the money on an LLC, don't want to spend the time it takes to put it together. How do you know if you're big enough to justify setting up an LLC? Let's talk through this. First question is, are you likely to be sued? And would that lawsuit be against you individually or your LLC? So let's say you have a contract with between a lawn mowing business and a homeowner. And the contract says the homeowner will pay $50 for you to mow the lawn. And let's say the contract also says if there are any problems, the homeowner will, or it says the LLC will be liable for any problems that occur. But here you are out there mowing the lawn, and let's say you start seeing a bunch of rocks, and you say, you know what, I'm just going to mow over those rocks. And as you go mow over those rocks, one of them gets propelled into a window and breaks it. The question now is, who is responsible for the window? Your LLC, you personally, or both of you? Well, if you said both of you, you're correct, and here's why. The contract between the homeowner and the business was with the LLC. So the LLC has liability for any breach of contract. And and also for any sort of negligence in the relationship. So LLC is liable. What about you personally, though? You might be saying, well, wait a second. I thought an LLC stands for limited liability company. In other words, my liability is limited. I'm not going to be liable if I have an LLC. There's a big exception to that most people don't realize. In fact, I've encountered attorneys who don't realize this. You're always liable for your own actions, even if you have an LLC. So if you're the one out there mowing a lawn and you negligently cause a rock to fly into a window and break it, your LLC is liable because that's the business providing the service, but you're also liable because you're the one that was negligent pushing the lawnmower. Now, if you weren't pushing the lawnmower and one of your employees was, that is where an LLC will protect you, because the business is liable for the employees and the business practices, but you are not liable because you did not do anything wrong. Could the homeowner sue the employee and the business? Sure. If the employee was negligent and the business works or employs the employee, both of them have liability. You might say, hey, why does the business have liability if the employee did something wrong? There's a Latin term called respondeat superior, and that simply means if a company has employees, contractors, or other agents doing work on its behalf, the company is liable. Respondeat is Latin essentially for responsible, and superior is essentially Latin for the person who is the superior or is in control or is in charge. So where the company is in charge, it is liable. And the company is in charge of its employees and its contractors. So back to the original question of when should a lawn mowing business have an LLC? Probably not until the lawn mowing business either has employees or contractors who are doing the work, so you're not the one behind the lawnmower pushing it, or the company is just so large that it has other risks that might be out there, or you're trying to build a brand name or something like that. So if the business is generating $15,000 to $25,000 a year, it probably makes sense to set up an LLC, even if you don't have employees. Also, too, there's a benefit with an LLC. It just shows that the company is a little more legitimate than just a guy or girl with a business. All right, let's take a look at the next question. Can you protect a secret recipe or formula or process without a patent? Yes, you can. So if you want to protect those, you have every right to go get a patent. And you need to get a patent within 1 year of the public knowing about this secret recipe, formula, or process. But let's say the problem with patents is they expire. Let's say you have a patent that lasts 23 years. In that case, after that expiration date, anyone else, all your competitors can use that. So imagine you are a company that makes a delicious chicken recipe. You might know who I'm talking about, Kentucky Fried Chicken or KFC. You have a right to patent that recipe, but then after the patent expires, you no longer have the exclusive right to that chicken recipe. So what are you to do? You put that recipe under lock and key, and you only let employees know about it who need to know. And you make reasonable efforts to keep it a secret. You don't let anybody outside the company know about it. And in fact, for practical reasons, you don't even let most employees know about that recipe. Obviously, some employees have to know because they're the ones running the machines that are formulating the batter, which creates such a good seasoning and flavor. So some employees know, and you have a very strict confidentiality policy for those employees. This is called trade secret law. And all states have what's called a Trade Secret Act, to my knowledge. And the federal government has a Trade Secret Act. Trade secret law and the Trade Secret Acts of the federal and state governments say that if you have a secret formula or recipe or process, as long as you make reasonable efforts to keep it a secret, nobody else can use it. Now, I get it. Not all secrets can be kept. You might want to take a look at patent. Patent protection will provide you other protection. For example, let's say somebody independently can figure out what your recipe is or comes up with a similar recipe on their own. Your trade secret law won't prevent them from doing that. But if you had a patent, nobody in the United States could use the patented recipe, formula, or process. So patent is very helpful in some circumstances. Trade secret protection is very helpful in other circumstances. To figure out what's right for you, I'd recommend meeting with a patent attorney. The patent attorney deals with this sort of issue on a daily basis. All right, Brendan has another question. If individuals or companies committing crimes knowingly commit perjury and deny their crimes, what's the best way to stop them from getting away with their crimes and wrongdoings without consequences? I'm concerned they'll lie. Should I write the judge? Should I meet with them in person? Go to the FBI and the U.S. Attorney for arrests? Well, this is a real frustrating situation. If you are dealing with a dishonest, unscrupulous, opposing party, what are you to do? You can work with law enforcement. You can work with your attorney to try to expose them as liars. There are a number of attorney techniques that we use when getting a party on the stand or in a deposition. Once a person starts making lies, you can often expose those lies. I won't go into the details here. There's plenty of information online about how attorneys can expose dishonesty in a deposition or on a stand. I actually love it when the other side starts lying, because you can't. One of the best ways to get in trouble in a lawsuit is to start lying, because now the judge doesn't believe a word you have to say. So I love it when the other side starts lying. And I tell my clients, whatever you do, tell the truth. And if you have a concern about telling some truth now, let's talk about it in advance and deal with it. But the last thing you want to do is lie in a court. So I'd say if the other side is lying, you and your attorney might celebrate, because now they have given you a gift that you can reveal them as the bad party and the party who should lose in a case. You do have a right to also contact law enforcement, but unless somebody is at risk of physical harm or some sort of serious financial fraud, law enforcement often doesn't like to get involved in this kind of stuff. And the federal government, they get told about million-dollar frauds all the time. So usually it has to be a huge situation for federal law enforcement like the FBI or even the Attorney General's office to get involved. So unfortunately, it is often up to you to use the court system and your own attorney to get justice when somebody else has hurt you. All right, next question. What are shareholders in a corporation? I was asked this by a newly hired paralegal one time, and I realized that she had never owned shares in a company. She had never bought stocks. She's not familiar with corporate law. She had a college degree. She was smart. She was kind. She was capable. But when it came down to what are shareholders in a corporation, that very simple question struck me as a little bit hard to answer. But here's the simple version. A shareholder is an owner of a corporation. It's just a business owner. If you have a corporation, you have shareholders, one or more. So if the business owner owns the entire corporation, they're the sole shareholder. Whether the corporation has 1 share or 100 shares, it doesn't matter. The shareholder is the sole owner of the corporation. But you could have 2 shareholders. Maybe they each own 50% of the shares of the corporation. You might say, hey, what are shares? Well, shares are just pieces of paper that say how much of a corporation do you own. So a corporation might have 100 shares, for example. That means if you own 15 of the shares, you own 15%. But a corporation could also have 1,000 shares. And if you own 10 of those 1,000 shares, you obviously only you own 1%. So a corporation, by the way, can usually create more shares or divide the shares. So if you have a stock split, let's say a corporation has 2 owners and they each own 50 shares, there are 100 total shares. If you have a stock split and every stock divides into 2, then the corporation goes from having 100 shares to 200 shares. And each owner goes from having 50 shares to 100 shares. Now, if you own 100 shares of a 200 share corporation, you have 50%. Likewise, if you own 50% of 100 shares of a corporation, you own 50%. So it doesn't matter how many shares you own, really. What matters is what is your percentage of ownership in the company. So that gives you an idea of what shares are. They are just documents that say, hey, this is how much you own of a company. And a company can be divided up many different ways. It just has to issue more shares. So shareholders are owners of a corporation. Contrast that with LLCs. In an LLC, members are the owner of the LLC. So just like shareholders own a corporation, members own an LLC. And we call all of them business owners. All right. We have gone almost 2 hours here. We still have a number of questions that have been submitted. But I took the questions first from those who attended live. Thank you to those who attended live today. If you would like to get notified about the next live session, you are welcome to subscribe to the Aaron Hall Attorney YouTube channel. You are welcome to subscribe to our little reminder email system at aaronhall.com/free. You can also sign up and follow us on other social media sites. I'm Aaron Hall, an attorney for business owners and entrepreneurial companies. It was a pleasure talking with you today and answering your questions from an educational perspective. As I always say, before you rely on any of this, consult with an attorney. It's my hopes that you use these questions to identify topics and questions to bring up with your attorney. Until the next live session, I hope you are doing well. Take care.